Ready? 5 seconds. Start. In 1993, the Indian Parliament enacted the Protection of Human Rights Act. The purpose of the act was to establish an institutional framework that could effectively protect, promote, and fulfill the fundamental rights guaranteed by the Indian Constitution. To this end, the Act created a National Human Rights Commission and also Human Rights Commissions at the levels of the various states. The national and state human rights commissions are examples of what we now call fourth branch institutions. According to the classical account, democracy is sustained through a distribution of power between three branches: the legislature, the executive, and the judiciary, with each branch acting as a check and a balance upon the others. However, the complexity of governance and administration in the modern world has necessitated the existence of a set of independent bodies which are charged with forming vital functions of oversight. Some of these bodies are constitutional bodies established by the Constitution itself. These include, for instance, the Election Commission and the Office of the Comptroller and Auditor General. Others have been established under law. For example, the Information Commission under the Right to Information Act and the Human Rights Commissions under the Protection of Human Rights Act. In the 2.5 decades of their existence, however, the functioning of the Human Rights Commissions has come under scrutiny and criticism. There have been the usual critics of the politician of autonomous bodies and selectiveness. Even more than that, however, it has been alleged that for all intents and purposes, the Human Rights Commissions are toothless. At the highest, they play an advisory role, with the government left free to disobey or even disregard their findings. In this context, a pending case before the High Court of Madras has assumed great significance. A full bench of the High Court will be deciding upon whether recommendations made by the Human Rights Commissions are binding upon their respective state governments, or whether the government is entitled to reject or take no action upon them. Under the Protection of Human Rights Act, the Human Rights Commissions are empowered to inquire into the violations of human rights committed by the state authorities, either upon petitions presented to them or upon their own initiative. While conducting these inquiries, the commissions are granted identical powers to that of civil courts, such as the examining witnesses, ordering for documents, receiving evidence, and so on. These proceedings are deemed to be judicial proceedings, and they require that any person who may be prejudicially affected by their outcome has a right to be heard. The controversy, therefore, the Madras High Court stems from the issue of what is to be done after the Human Rights Commission completes its inquiry and reaches a conclusion that human rights have been violated. Section 18 of the Protection of Human Rights Act empowers the Human Rights Commission to recommend to the concerned government to grant compensation to the victim, to initiate prosecution against the erring state authorities, to grant interim relief, and to take various other steps. The key question revolves around the meaning of the word recommend. Stop.